"Ma'am," he said, turning toward the woman. She was the kind of woman who could silence a room with a look, and right now the whole courtroom felt like it was holding its breath. "Ma'am," he said, turning toward the woman seated near the clerk's desk, "you're the custodian of records from the county recorder's office." "Yes, Your Honor," she replied. "Then read the recording number into the record," he said, out loud, slow. My sister's attorney shifted beside her, still wearing that confident half smile. My sister, Sloane, sat like she owned the bench, chin tipped up, hands folded neatly on a folder that was way too thick to be innocent. And my mother, Deborah, sat right behind her, face calm, as if we were at a school meeting and not a hearing about my home. The clerk from the recorder's office looked down at her printout, adjusted her glasses, and began. "Instrument number," she read, to 2026-011847. My stomach dropped so hard it felt like my body forgot how to sit, because I'd seen that number before. Not online, not in a database. In my mother's handwriting, on a sticky note she'd left on her kitchen counter weeks ago. A sticky note I'd taken a picture of because something about it made my skin prickle, even then. And now it was being read in open court like a gun serial number. The judge glanced up. "Miss DeHart," he asked the recorder clerk, "what is that instrument?" The recorder clerk kept reading, flat and professional. "Quit claim deed," she said. "Recorded under this instrument number. Grantor, Claire Bennett. Grantee, Claire Bennett and Sloane Bennett as joint tenants." My sister's smile didn't move. My mother's face didn't move. But I felt my pulse slam in my ears like a warning siren. Because that was my house. My name was Claire Bennett, and I never added my sister to anything. And if you'd asked me a month ago how this happened, I would have said it couldn't. My mom wasn't the type to kick down doors or scream in public. She didn't need to. She had a softer weapon. I'm only trying to help. It started with a casual conversation at her kitchen table. "Your property taxes are going up again," she told me, stirring her coffee like she was discussing the weather. "Let me update some paperwork. I can get you the right forms." I remember laughing and saying, "Since when are you the paperwork fairy?" She smiled, small, sweet. "Since you're busy, and I'm not." I didn't think twice. That was the thing about my mom. She didn't come at you like a villain. She came at you like a solution. A few days later, she asked for my house documents, just to compare something, and I emailed her my deed from my closing packet without a second thought. Not the original, just a PDF, boring, harmless. Then a week after that, she mentioned my sister in the same breath. "Sloane's doing so well," she said. "You know, it wouldn't hurt to have her name on things, just for family security." I felt my shoulders tighten. "My house isn't a group project." Deborah shrugged. "It's just a name. Don't be dramatic." That phrase, "don't be dramatic," was her favorite way of sanding down your instincts until they didn't work anymore. 2 weeks later, I got a weird piece of mail, a county notice addressed to both me and Sloane. I assumed it was junk. That night, and I pulled up the county property portal just to be sure. Owner, Claire Bennett and Sloane Bennett. I stared at the screen until my eyes burned. Then I pulled my deed from my own records and compared it to what the county had on file. Same legal description, same parcel number. New name added like it had always been there. I drove to my mom's house without calling first. Deborah opened the door in slippers, calm as ever. Sloane was in the living room, legs tucked under her, smiling at her phone like she didn't have a care in the world. I held my laptop up like a flashlight. "Why is she on my deed?" I asked. My mom didn't flinch. "Because it's safer." "For who?" I said. Sloane looked up and gave me that smooth little smile, like she'd been waiting for me to notice. "It's not a big deal," she said. "It's already recorded." Recorded, like she'd pressed a button and the universe had agreed. I turned to my mom. "Did you file a deed?" Deborah sighed, like I was exhausting. "I updated paperwork," she said. "You'll thank me later." And that's the moment I stopped trying to reason with them, because you can't reason someone out of a plan they made with intention. I went home and called my title insurance company. Then I called a local real estate attorney, Janet Lowell, a woman whose voice sounded like she'd ended 100 scams before lunch. She didn't gasp. She didn't give me a lecture. She asked one question. "Did you sign anything in front of a notary?" "No," I said. "Never." "Then we treat it like what it is," she said. "A fraudulent deed." She explained it in plain English. A deed doesn't magically update. Someone records a new one. And if your signature is on it, someone either fooled you or forged you. Janet filed an emergency request to block any sale or refinance and recorded a notice that the title was disputed. And she also subpoenaed the county recorder's custodian of records for a hearing, because judges don't move fast on feelings, but they move on records. Sloan showed up to court with an attorney and a smile. Deborah showed up looking wounded, like she was the one being wronged. And now the recorder clerk had just read the instrument number into the record, the same number I'd seen on my mother's counter. The judge tapped his pen once. "Ms. Bennett," he said to me, You're telling this court you never signed this deed." "That's correct," I said. "And you recognize the recording number?" he asked. My throat went tight. "Yes," I said quietly, "because I've seen it before. In my mother's possession. Before I even knew my name had been changed in the county records." My sister's attorney's smile finally slipped, just a fraction. The judge's eyes sharpened. "Then," he said, "we're going to talk about how that deed got recorded and who walked it in." The judge didn't look at my sister when he said it. He looked at the recorder clerk. "Ms. Hart," he said, "walk me through how an instrument number like that gets assigned. From the moment the deed arrives at your office." Ms. Hart nodded, the way people do when they've explained the same process 100 times. "When a document is presented for recording," she began, "we log it in, collect fees, scan it. When it's indexed under the parcel, the instrument number is assigned at intake and follows it through the recording." "And this deed," the judge asked, "how was it presented?" Ms. Hart glanced at her printout. "In person," she said. "Front counter drop-off." My sister's attorney shifted in his chair. The judge's eyes narrowed slightly. "So someone physically walked a quitclaim deed into the recorder's office?" "Yes," Ms. Hart said. My mother's face stayed calm. Too calm. The judge turned a page in the file. "Do you keep a recording packet?" he asked. "Yes," Ms. Hart said. "There's a cover sheet with return information, fee receipt, and the scanned deed." "Bring it up," the judge said. "I want the return to information read into the record." Ms. Hart typed, clicked, then read. "Return to after recording. Deborah Bennett," she said, and my mother's name sat in the air like a weight. "Mailing address listed." My sister's smile didn't survive that. When it fell off her face like it had been pulled, the judge looked straight at my mother. "Mrs. Bennett," he said, "why is your name listed as the return recipient on a deed that changes ownership of your daughter's home?" My mother opened her hands like she was offering peace. "I was helping," she said. "She's always overwhelmed. I told her I'd handle the paperwork." The judge didn't react to the word helping. He asked the only question that mattered. "Did your daughter authorize you to record a deed adding her sister to the title?" My mother's eyes flicked to me for half a second, like she was deciding whether to lie big or lie small. "I didn't add anyone," she said carefully. "I updated family paperwork. It was meant to protect the house." "Protect it from what?" the judge asked. My sister answered before my mother could. "From her," Sloan said, voice smooth. "She makes impulsive decisions. She'd sell it the moment she got stressed." I felt my jaw tighten, but I didn't jump in. That was her trap. Get me heated, then point at me like proof. My attorney Janet stayed calm. "Your Honor," she said, This isn't about opinions. My client never signed the deed, never appeared before a notary, and never consented to adding anyone to title. The judge tapped his pen once. Then we go to the notary, he said. Ms. Hart was already flipping pages on her printout. The deed includes a notary acknowledgement, she said. Name and commission, the judge ordered. Ms. Hart read it out. Janet didn't miss a beat. Your Honor, she said, we requested the notary's journal entry. The county recorder's supervisor provided a certified copy. She stood and handed a single page up to the clerk, clean, stamped, boring in the way that ends arguments. The judge read it once, then he looked up. Mrs. Bennett, he said, yeah, you claim this was just paperwork, but this notary record shows someone appeared and signed as your daughter. My mother's face tightened. It could have been electronic. People do things online now. Janet didn't roll her eyes. She didn't sigh. She simply answered like she was explaining it to a normal person. A deed still requires a real acknowledgement, she said. A person has to appear before a notary. That's the point. The judge leaned back. Ms. Hart, he said. Do you have the intake log? Who dropped this off? Ms. Hart nodded. Yes, Your Honor. He held up a hand. Read it. She read the line in the same flat voice as before. Submitted in person, she said. Name on intake, Deborah Bennett. My mother blinked fast. My sister's attorney went still, and I felt something inside me settle, because now it wasn't a vague feeling. It was a record. The judge stared at my mother for a long beat. Mrs. Bennett, he said, yes, you physically delivered the deed that removed your daughter's sole ownership and added her sister. My mother tried to keep her tone soft. I didn't remove anything, she insisted. She's still on it. It's not like I took it away. It changed her rights, the judge replied. That is not. Nothing. Then he turned to my sister. Miss Bennett, he said, why are you on this deed? Sloane lifted her chin. Because our mother wanted it that way, she said. And because it's family. The judge's mouth tightened. Family isn't a legal category, he said. Ownership is. Janet stepped forward again. Your Honor, she said, my client took a photo of the recording number weeks ago, before she even discovered her title had been altered. It was written down in her mother's possession. The judge's eyes flicked to me. I pulled my phone out, handed it to Janet, and she showed the photo. Sticky note, the same instrument number. This, Janet said, is why the recording. This, Janet said, is why the recording number matters. It ties the planning to the act. My sister's attorney finally spoke. Your Honor, he said carefully, this is all speculation. The defendant is still on title. No harm has occurred. The judge cut him off. No harm? He repeated, voice flat. A deed that changes ownership rights is harm, or especially if it wasn't authorized. He looked at Ms. Hart. Ms. Hart, he said, can your office provide the scanned recording packet, cover sheet, fee receipt, and the deed image certified? Yes, she answered. Do it, he said. And I want preservation on anything associated with intake. If there's footage at the counter, preserve it. My mother's face finally cracked. Footage, she said too quick. The judge looked right at her. Yes, he said. Footage. Because now he wasn't deciding whether I was dramatic. He was deciding whether a deed was recorded through fraud. He glanced down at the notary page again. Next, he said, I want the notary here. I want the journal. And I want to know who appeared, what ID was used, and who paid for the notarization. My sister's attorney swallowed. My sister didn't smile anymore. Joanne, my mother, who had been so calm in her slippers a month ago, looked like she was realizing the difference between a kitchen conversation and a courtroom. The judge set his pen down and said the one thing that made my sister's shoulders stiffen. Until I sort this out, he said, there will be no sale, no refinance, no transfer, and no new documents recorded against this property without court review. Then he looked at Sloane. "And if you use this deed to pressure your sister," he added, "that will matter." My sister's eyes flicked to my mother like she wanted an exit. The judge leaned toward the clerk. "Set this for an evidentiary hearing," he ordered, "and issue subpoenas for the notary, the journal entry, and any available intake footage." He looked back at me. "Ms. Bennett," he said, "you did the right thing asking for the recording number." My throat tightened, because that one number didn't just change my life. It changed the direction of the case. And I could already feel it. Once the notary journal came in, somebody was going to have to explain a signature that wasn't mine. The court moved faster than I expected. Not because anyone felt sorry for me, courts don't run on sympathy, but because the judge could see the shape of something bigger than family tension. When we came back for the evidentiary hearing, the courtroom felt different, tighter, quieter. I wanted to look reasonable. Sloane arrived. Wanted to look reasonable. Sloane arrived with the same lawyer and no smile this time. She held her folder like it was a shield, and then the notary walked in. A man in his late 50s wearing a polo under a sport coat, carrying a hardbound journal like it was a Bible. He looked straight ahead, not at me, not at my sister, not at my mom, like he'd been trained to not take sides. The bailiff swore him in. The judge didn't waste time. "State your name for the record," he said. The notary did. "Are you the notary whose stamp appears on the quitclaim deed, recorded under instrument number 2026-011847? The judge asked. "Yes," the notary answered, voice steady. The judge tapped the deed in front of him. "Did Claire Bennett appear before you and sign this deed?" he asked. My stomach tightened, because if he said yes with confidence, the next hour would get ugly. The notary hesitated, just a fraction, then said, "I notarized a signature on that date. Yes." Sloane's attorney leaned back like he'd been waiting for that sentence. My mother's shoulders loosened, barely. Janet didn't flinch. She stood. "Your Honor," she said, "may I ask the notary to produce his journal entry for that notarization?" The judge nodded. "Show me the journal." The notary opened the book, flipping to a tabbed section, then set it on the witness stand. The judge leaned forward. "Read the entry," he ordered. Slow. The notary traced the line with his finger. Date. Time. Document type. Quitclaim deed, he read. Signer listed as Claire Bennett. He kept going. ID presented, driver's license, he read. Were state, Nevada. My entire body went cold because I've never had a Nevada license, not even close. Janet didn't jump in with outrage. She just asked, calm, "Can you read the last 4 digits of the license number you recorded?" The notary read them. Janet looked at me for half a second, then handed up a copy of my real license information. State, number format, everything. The judge compared the two and his mouth tightened. "Those are not the same," he said flatly. Sloane's lawyer stood up too fast. "Your Honor, it's possible the notary made an error." The judge cut him off. "Possible," he said, "but then the question becomes, who was actually in front of the notary?" He looked at the notary again. "Did you photocopy the ID?" the judge asked. The notary nodded. "We scan ID for our records." "Produce it," the judge said. The notary opened a folder he'd brought, pulled out a printed scan, and handed it to the clerk. When the clerk placed it in front of the judge, I saw the corner of it from where I sat. It had my name. It had a photo that looked like me. If someone had described me to a sketch artist and said, "Close enough." And it had a Nevada logo I'd never seen on any ID I've owned. The judge stared at it for a long beat, then asked the notary something that made the room go even quieter. "Who paid for the notarization?" The notary blinked. "Excuse me?" "Who paid?" the judge repeated. "Cash, card, invoice. How was it paid?" The notary checked his entry. "Card," he said. I wrote, "Card ending in 6829. Janet stepped forward with a single page. "Your Honor, we subpoenaed the merchant receipt," she said. "The notary business provided it this morning." The judge took the page and read it. Then he looked up at Sloan. "Ms. Bennett," he said, "this receipt is under the name Sloan Bennett Holdings." My sister's face didn't just change, it drained. Because that wasn't Mom doing paperwork. That was Sloan paying for the moment my name got changed. Sloan's lawyer tried to speak, but no sound came out for a second. My mother whispered something to Sloan, too fast to catch. The judge didn't allow the moment to float away. He leaned forward. "Notary," he said. "Who physically presented the ID?" The notary swallowed. "I don't remember the face clearly," he said, careful. But I remember there were 2 women." Janet's voice stayed calm. "2 women? Yes," the notary admitted. "One did most of the talking." The judge's eyes flicked to my mother, then to my sister. Then he asked, quietly, "Is there surveillance footage in your office?" The notary hesitated. "We have cameras." "Preserve it," the judge ordered, "and you will produce it." Sloan's lawyer stood. "Your Honor, this is turning into a criminal inquiry." "No," the judge said, sharp. "This is turning into a truth inquiry. The criminal part is not my job, but I can stop the damage." He looked down at the deed again. "Ms. Hart," he said to the recorder clerk, "what is the current status of the record? Is this deed active?" Ms. Hart answered, "It is recorded and indexed, Your Honor." "Can your office place a fraud alert flag on the parcel?" the judge asked. "Yes," Ms. Hart replied, "with a court order." The judge nodded once, then looked at Janet. "Counsel," he said, "do you have reason to believe the deed is being used to sell or refinance?" Janet didn't glance at me. She reached into her folder and pulled out one page. "Yes," she said. She handed it up. The judge read the header, and his eyes narrowed. It was a title company email confirmation. Short, clean, and terrifying. "Open escrow file. Property inquiry received." My stomach flipped. Janet kept her voice even. "My client received an automated title alert yesterday," she said. "An inquiry was initiated using the newly recorded deed." Sloan's lawyer tried to stand again. "That proves nothing," he said quickly. "An inquiry can be—" The judge cut him off with a look. "An inquiry plus a fabricated ID plus a paid notarization," he said, "is plenty." Then he turned to my mother. "Mrs. Bennett," he said, "you told this court it was just a name and just paperwork." He paused. "Now I have. Your name on the recorder intake log? Your name on the return to cover sheet, your daughter paying for the notarization, and a fake ID used to impersonate Claire Bennett." My mother's lips parted. No words came out. The judge looked at Sloan. "And you," he said, "benefit from the deed. You paid for the notarization, and an escrow inquiry has already been initiated." Sloan's face tightened. She said finally, "It was supposed to be temporary." The judge's voice went flat. "Deeds aren't temporary," he said. "They're recorded." Then he gave his order, slow and clear, like he wanted every word to stick. "Effective immediately," he said. "This court is issuing a temporary restraining order. No sale, no refinance, no transfer, no new recording activity against this parcel. The county recorder will place a fraud alert flag today. The title company will be notified today, and the notary will preserve and produce all footage and records." He turned to the clerk. "Prepare the written order," he said. "Are now." The clerk began typing. Sloan's lawyer leaned toward her, whispering fast, and for the first time Sloan looked like someone who realized a plan had consequences outside the family. My mother stared straight ahead, rigid. Janet leaned toward me and murmured low, "This is the second they stopped treating it like family." Before the judge could adjourn, Ms. Hart, the recorder clerk, spoke again. "Your Honor," she said, "There's one more note in the recording packet." The judge looked up. "What note?" Ms. Hart glanced down at her printout. "On the intake cover sheet," she said, "there's a handwritten reference, a cross-reference number." My pulse spiked. "A cross-reference to what?" the judge asked. Ms. Hart swallowed. "To an earlier instrument," she said, "a prior recording number." The judge's eyes narrowed. "Read it," he ordered. Ms. Hart read the digits out loud, and then I felt the air leave my lungs. Because that prior recording number was the one I'd seen months ago on a different sticky note, on the same counter right next to the words, "Backup Deed." Janet's head turned toward me slowly. The judge's pen stopped moving, and my sister's lawyer, who'd been so confident in part one, finally looked like he'd found the edge of a cliff. The judge leaned forward. "Ms. Hart," he said quietly, "pull that prior recording file." Ms. Hart nodded once. "Yes." "Your Honor," she said, "but it's sealed in our archive." The judge's gaze lifted to my mother. "Then," he said, "we're going to open the archive." Because if there was a backup deed, this wasn't one bad decision. It was a plan. They didn't send us home to come back later. The judge wanted it now. He called a short recess, and Ms. Hart from the recorder's office disappeared through a side door with the court clerk. Janet leaned toward me and whispered, "Don't look back. Why, let them scramble." I tried not to, but the room was full of small noises that felt huge. Papers shuffling, a chair scraping, my mother's slow, controlled breathing. Sloane's attorney kept whispering to her, fast and tight. My sister just stared straight ahead, jaw locked, like she could will this into being just paperwork again. 10 minutes later, the courtroom door opened, and Ms. Hart returned. Only she wasn't alone. A woman in a navy blazer walked in beside her with a county badge clipped at the waist and a sealed clear evidence sleeve in her hands. The kind of sleeve you see when something is being handled like a real record, not a casual printout. The judge sat forward. "Ma'am," he said, "state your name." "Deputy Recorder Lynette Shaw," she answered. Her voice was steady and blunt, like she'd spent her career dealing with people who thought stamping something made it true. And the judge nodded to the sleeve. "Is that the prior recording file referenced on the intake cover sheet?" "Yes," Lynette said. "It's from our rejected recordings archive." "Rejected?" Sloane's lawyer blurted before he could stop himself. The judge gave him a look that shut him down. Lynette didn't even glance his way. She kept her eyes on the bench. "Some recording packets are not accepted," she explained, simple and clean. "Wrong fees, missing pages, improper notary acknowledgement. Things like that. They don't become public record, but we retain the packet and the audit trail." My skin prickled. So a backup deed wasn't just a dramatic phrase. It was a real packet sitting in a county archive, waiting. The judge gestured. "Hand it to the clerk. I want chain of custody noted." The bailiff opened the sleeve. The clerk logged it, and Lynette placed the packet on the bench like it was heavier than paper. The judge flipped the first page, and his face tightened almost immediately. "Ms. Hart," he said, "read the return to information." Ms. Hart read without emotion. "Return to after recording. Deborah Bennett." My mother's name again. My mother exhaled through her nose, like she was annoyed at how often her name had to appear. Then Lynette spoke up. "Your Honor, there's more," she said. Now, the packet includes a handwritten instruction note attached to the cover sheet. The judge held it up between two fingers. It was a yellow, sticky note taped to the county form, and I recognized the handwriting before I even read the words. My mom's handwriting. The judge looked at Lynette. "Is this part of the retained packet?" "Yes," Lynette said. "It was attached at intake." The judge turned to the clerk. "Read it into the record," he said. The clerk's voice stayed steady. But the room felt like it leaned forward. "If this one gets rejected, use the other deed. Keep both numbers." My mouth went dry. Sloane's attorney stopped moving entirely. My mother's face finally changed. just a hair, like she'd been slapped with her own handwriting. Janet didn't react. She just stood, calm, and said, "Your Honor, may we mark that note as an exhibit?" "Mark it," the judge replied. "Stamp, logged, real." Then the judge flipped to the actual deed inside the rejected packet, and he stared at the signature page for a long beat and then looked up at Lynette. "Why was it rejected?" he asked. Lynette pointed to a corner. "Notary commission was expired," she said. "Our intake staff flagged it. It was rejected the same day." The judge nodded slowly. "And what did this deed attempt to do?" Lynette didn't answer. She let the document answer. The judge looked at Ms. Hart. "Read the grantee line," he ordered. Ms. Hart read it out loud. "With grantee, Sloan Bennett, as sole owner." A low, involuntary sound came from somewhere in the gallery. My sister didn't flinch, but her lawyer's face went pale around the mouth, because this wasn't "Mom added a name." This was a second deed, prepared to wipe me off completely. Janet spoke, voice calm and sharp. "Your Honor," she said, "that means there were two attempts, one to add her and a backup to remove Claire entirely." The judge's eyes moved to my mother. "Mrs. Bennett," he said, "when you told your daughter this was just a name." He tapped the rejected deed. "This is not just a name. This is a plan to take a house." My mother's lips parted, then pressed together. She didn't answer. The judge didn't let the silence help her. "Who prepared this deed?" he asked Lynette. Lynette checked the cover sheet. "Prepared by Deborah Bennett," she said. The judge's jaw tightened. He flipped a page and paused again. "Gentlemen, who paid the recording fees, attempted fees, on this rejected packet?" Lynette didn't hesitate. "Card ending in 6829, she said, referencing the receipt stapled to the file. Janet stepped forward and handed up another page. "Your Honor, that card is linked to Sloan Bennett Holdings," she said simply. Sloan's attorney sat down so hard his chair made a sound. My sister finally turned her head and stared at my mother, eyes hard. Leaned back, then forward again. Voice leaned back, then forward again, voice controlled. "Ms. Bennett," he said to Sloan, "you paid for a notarization on a deed that attempted to make you sole owner of a property you did not purchase." Sloan's attorney stood up, hands slightly raised. "Your Honor, we object. There's no proof my client knew." The judge cut him off. "She paid for it," he said. "Then her entity name is on the receipt. That's proof enough for today." Then he turned to my mother again. "Mrs. Bennett," he said, "did you sign this deed or present it for notarization?" My mother finally spoke, voice thin. "I was trying to keep the house in the family," she said. "In the family," the judge repeated. He pointed at me. "She is your family." My mother's eyes flicked toward me and away. Sloan tried to speak, but Janet was faster. "Your Honor," Janet said. "See, we also have confirmation an escrow inquiry has already been opened using the recorded deed." The judge's pen stopped. He looked at Lynette. "Can the recorder's office issue an immediate certified packet on both the accepted deed and this rejected attempt?" "Yes," Lynette said. "We can certify the accepted recording and provide certified copies of the rejected packet under court order." "Do it," the judge said. Then he looked at the clerk. "I want an order issued today," he said. "We're directing the county recorder to record my restraining order and a notice of disputed title." He looked at Sloan. "And I want the title company notified," he added. "If an escrow file exists, it's to be frozen." Sloan's lawyer tried again, voice urgent. "Your Honor, this is excessive." The judge's eyes narrowed. "What's excessive," he said, "is using forged identity paperwork and fake ID to change a deed. We are past family misunderstanding." He turned to the bailiff. "Bailiff," he said, "I'm ordering preservation of devices. Mrs. Bennett and Ms. Bennett will preserve phones, emails, and any documents related to these deeds. No deletions, no resets." My mother's head snapped up. My phone? She asked, offended. The judge didn't flinch. Yes, he said, because your handwriting is now an exhibit. Then he leaned forward and said the sentence that made Sloane's attorney's throat bob. And, the judge added, I am referring this matter to the district attorney for review of fraudulent recording and identity fraud. My sister's face drained of color in a way I'd never seen before. For the first time, she looked less like someone playing a power game and more like someone realizing the board had teeth. The judge wasn't done. He looked at Lynette. One more question, he said. On the accepted deed, the one that actually recorded, does your office retain an audit trail that shows who submitted it and when? Lynette nodded. Yes, bring it, the judge said, because if this was walked in twice, I want the timeline. Lynette opened a folder tab and handed the clerk a single sheet. Ms. Hart read the top line. Intake name on the accepted deed, she said. Deborah Bennett. Time, 9:12 a.m. The same time from the earlier log. On my mother's shoulders sagged a fraction, because now she wasn't helping from the kitchen. She was standing in a county record trail twice. The judge looked straight at me. Ms. Bennett, he said, today I stopped the bleeding. He glanced at my mother and sister. Next, he said, we restore the record and determine responsibility. Then he turned to the clerk. Set the final hearing, he ordered. And make sure the written orders are stamped and recorded today. Janet leaned toward me, voice low. That backup deed, she murmured. It just saved you. I swallowed, staring at my mother, at the woman who had smiled over coffee and called me dramatic. Because now the court had her handwriting, her intake log, her return address, and a rejected deed that tried to erase me completely. And the only thing left was the part everyone was going to care about. What happens to them after the judge signs the order? The judge didn't waste time after the recess. He sat down, looked at the two deed packets, one recorded, one rejected, and then looked straight at my mother. Mrs. Bennett, he said, I'm going to ask you a simple question. My mom lifted her chin like she was ready to act wounded again. Why? Her mouth opened, closed. The judge waited. Finally, Deborah said, I was trying to keep it safe. Safe from what? The judge asked. My sister's attorney started to stand, but Sloane cut him off with a sharp whisper. Her eyes were fixed on the bench like she could intimidate paper. Deborah's voice dropped. Sloane's business was in trouble. The courtroom got very still. Deborah kept going, fast now, like she'd decided the truth was less dangerous than the evidence. She needed collateral, she admitted. Her bank wanted something solid. She said it was temporary, just for paperwork. I felt my stomach turn. So that was the updating paperwork. My home as a spare tire for my sister's finances. The judge looked at Sloane. Ms. Bennett, he said, did you intend to use your sister's home as collateral? Sloane's jaw tightened. Then she said, flat, it's family. The judge didn't blink. Family doesn't authorize forgery, he replied. Janet stepped forward and handed up one more exhibit, an email printout I'd never seen until yesterday. Your Honor, she said, this is a conditional approval notice from North Harbor Bank to Sloane Bennett Holdings. It references title update as a requirement. Sloane's lawyer went rigid. The judge read the header, then the line that mattered. His eyes lifted slowly. So this wasn't a misunderstanding, he said. This was a financing plan. Deborah's shoulders sagged like she'd finally run out of excuses. The judge leaned forward. Here's what we're going to do, he said, voice calm, controlled, and final. He held up a pen and started counting without drama, because he didn't need drama. 1. I'm converting the temporary restraining order into a preliminary injunction. No sale, no refinance, no transfer. No recording activity against this parcel without court review. 2. I'm ordering the county recorder to record today's order and a notice of disputed title. Fraud alert flag goes on the parcel today. Lynette from the recorder's office nodded once, already writing it down. 3, the judge continued. Miss Bennett. He looked directly at Sloan. You will execute a corrective quitclaim deed, relinquishing any claim to this property within 48 hours. Sloan's attorney jumped up. Kim, Your Honor. The judge cut him off. If she refuses, he said, still calm, I will authorize the clerk of this court to execute it on her behalf. That sentence landed like a steel door. Sloan finally looked rattled, not because she felt bad, because she could see her plan collapsing in real time. 4, the judge said. I'm awarding attorney's fees and costs to Ms. Bennett. He nodded toward me. For bad faith conduct and emergency filings. Counsel will submit the amount. I will sign it. My mother made a small sound like she wanted to protest but didn't. The judge didn't look at her yet. 5, he said. This matter is referred to the district attorney for review of fraudulent recording, identity fraud, and false filings. The notary's records and footage are to be preserved and produced. Then he finally looked at Deborah. Mrs. Bennett, he said, you walked these documents in. Your handwriting is in the packet. This court is not a tool, he said. This court is not a tool, he said. We are adjourned. Janet didn't celebrate in the hallway. She moved like someone who knows timing is everything. We went straight from the courtroom to the recorder's office with Lynette. No waiting, no next week. Lynette walked us to a counter window that wasn't open to the public and handed over the signed order. And the clerk stamped it, logged it, and printed a receipt. Recorded, time-stamped. Fraud alert placed. Lynette pointed at the receipt like it was the only sentence that mattered. That, she said, is the door closing. Then Janet called the title company that had opened the inquiry. She put it on speaker in the parking lot so I could hear the confirmation with my own ears. We received the court order, the title officer said. File is frozen. No escrow will proceed. Till we flagged the parcel for fraud review. Janet asked for it in writing. 2 minutes later, an email hit my inbox. File closed. Fraud hold. No action without court clearance. My body finally stopped bracing, not because I won, because my house stopped being a moving target. 2 weeks later, the consequences arrived in the boring way they always do. Letters, numbers, and official phrasing. A certified envelope came to Janet's office with a case number at the top. District Attorney Intake. Reference number included. I didn't need every detail spelled out to understand what it meant. My mom and sister weren't just in a fight anymore. They were in a file. The same week, Sloan's lawyer emailed Janet requesting a payment plan for the attorney's fees the judge had approved. Not might approve. Approved. And then, the part that felt almost surreal, North Harbor Bank sent a notice to Sloan Bennett Holdings. Application withdrawn. Adverse title findings. My sister had tried to use my home like a lever. Instead, the lever snapped and fell on her own foot. Deborah didn't call me after that. Not once. The only thing she sent was a short text, 2 lines with no apology inside it. I didn't think it would go this far. Please don't hate me. I stared at it for a long time. Then I did the most important thing I've learned to do with people who confuse family with permission. I didn't answer right away. I forwarded it to Janet. Because in this situation, silence wasn't punishment. It was boundaries. By the end of the month, my deed was back to what it had always been. My name only. Not because my mother fixed it. Because the court made it unavoidable. And I kept 3 things in a folder in my kitchen drawer. The recorded court order receipt, the title company, file closed email, the corrected deed confirmation. That's my version of peace now. Not a hug, not a family dinner. Proof that my life can't be rewritten while I'm not looking. And when people ask why I went this far over just a name, I tell them the truth. Names on deeds aren't names. They're doors. In the moment my mother tried to hand my door key to my sister, I stopped being polite. Not because I wanted revenge, because I wanted it to stop.